Okay, if I could have your attention, please. We'll go ahead and get started. We've got the most important person here now, so thank you very much. Thank all of you for being here today. Got a little housekeeping I want to take care of first. We've got 4 bills that I want to assign to subcommittee, and those of you who want to make notes, House Bill 922 by Representative Jacobs is being assigned to the Knox subcommittee. House Bill 960 by Representative Lynn Walker is being assigned to the Knox subcommittee. House Bill 968 by Representative Jacobs is being assigned to the Mumford subcommittee, and House Bill 902 by Representative Clay Cox is being assigned to the Mumford subcommittee. Let me also, before we take up today's agenda, recognize our Judge of the Week, Judge Lawton Stevens from the Western Judicial Circuit. Is that more known as Athens, Clarke County, and Oconee County? Okay. All right. We have 3 bills. We did have 4 bills on the agenda today. House Bill is at 92. At the author's request has been deferred. We'll take that up at a later date. So we're going to get started with House Bill 259. Representative Geisinger. Come around, Representative Geisinger. We're pleased to have you with us. What you need?
Thank you, Mr. Chairman. Mr. Chairman, if this bill looks familiar, it should. 259 passed out of this committee last year without a dissenting vote, and we ran out of time at the end of the session, as we have found that we do frequently. Also, I would hope in the future we could change our rules so we don't have to take the committee's time to rehear bills that have already been passed out, but that's an issue for another day. Mr. Chairman, as you may or may not recall, this bill came out of a suit that was filed against AT&T and Piggly Wiggly, and they were both fined for holding contests. And if Mr. Les Snyder would pass out some of the material, you can see the contests that are held throughout the state of Georgia continually. We all experience them all the time. Home Depot, Atlanta Symphony, AARP, they're all operating illegally within the state of Georgia as the way the law is stated today. All this does is correct that problem. Mr. Chairman, if there are no questions at this point, because you have heard this bill before, and as I say, it passed out unanimously, I have nothing else to say unless Mr. Snyder would like to.
There are questions, and do y'all wish to take them up before or after we hear from the other speakers? Excuse me? Okay, I'll recognize you at a later time. Let's see. Who's 13? Is that Representative Franklin? Chairman Franklin.
Thank you, Mr. Chairman. I like the direction of where you're trying to go with the bill. But one thing that has been coming across my mind, I'm a Republican, and a number of us in the room are, and I've noticed, however, that we're not trying to reach the end objective in a freedom-oriented way, and I'm wondering if we might want to try to do a little bit of redraft in a tyranny model like the Soviet Union had. Everything was prohibited unless it was specifically permitted. In other words, we're permitting this type of activity here, and I like what we're trying to accomplish. Being in favor of freedom. And in a freedom zone, like our country used to be, everything is permitted unless it's specifically prohibited. And would you be willing to go back and look to see what in the Georgia Code specifically prohibits this activity that we're trying to allow, and then repeal whatever it is that's keeping these things from being done currently? Would you be amenable to look to see what needs to be repealed that's prohibiting this activity now?
Representative Franklin, I hear where you're going, but I think that's an issue for another day with legislation that would be much broader than what we're talking about here. We're trying to correct a problem that exists today so that these other firms are not finding themselves in court and fined for breaking the law.
Right, and I commend that they shouldn't be. But my whole point is what about looking to see what's prohibiting them from legally doing what we're wanting them to be able to do with this legislation, and actually repealing those code sections that prohibit it now, instead of adding new code section, new language that gives them a carve-out exemption that permits the activity. It's a different way of looking at it, I know, but as a Republican, I like the idea of freedom, and would rather the presupposition be that it's going to be everything to be legal unless we specifically prohibit it. So obviously there's something that we prohibited that we need to, that would be, in my opinion, would be nice to repeal that prohibition that would allow this activity.
Representative Franklin, I want to point out to you that we have been working on this. My letter from the Attorney General in regards to this, stating that it is illegal what they're doing today, was dated 2004. So, you know, I don't want to dilly-dally anymore. I don't disagree with you, but I think we need to take that up at another day. But Mr. Snyder, I believe, can answer the question more thoroughly.
Representative Franklin, what we're really trying to straighten out is what language are we doing to do it. If you look on page 2 of the bill, and you see line 4. Sure.
Here, but let's be clear, because we've got two things in the folders. Representative Geisinger, if I am understanding, you were asking us to consider the original bill.
Yes, sir.
As opposed to the committee sub that was adopted last session.
Yes, sir.
Which is LC 283355 for members of the committee. I'm sorry, Les. I just wanted to make sure we're looking at the same thing on page 2.
I appreciate that. Again, on page 2, line 4, Representative Franklin, the problem that ensued from the two cases, and I don't think anybody really anticipated that, the General Assembly originally had said no person to be eligible to receive such prize shall be required to do any of those three things. Well, I think the General Assembly, when they passed it, said, well, if you're not required to do it, that means you could do it for free and it would be okay. But these two court decisions, one a federal court and a state court, both read that line to say that if somebody entered for free, if somebody else paid to enter as their choice, that was a violation of the law. And that's why I think we are getting at the issue you're talking about. It was a matter that I think the General Assembly was clear in its language, but for some reason two courts disagreed and put Georgia in the minority of states. We're only 2 of 50 states that interpreted it the way it was in those two cases. With this language, it is clear that as long as someone can enter a promotion for free, the fact that somebody else pays because they purchased something to enter and it's entered automatically, they in fact will not become anything illegal. And that was the precise language that was changed. And I think when this thing was first passed, everybody said, shall not be required. And therefore, that should be all right. But obviously, two courts disagreed. That's why, on behalf of some nonprofit organizations and some businesses, we want to make sure it's fair.
Was there something in that legislation that was contrary to the state constitution?
No, what happened was, again, these two courts.
Or did the branch across the street decide they wanted to be a lawmaking body?
As an attorney, I don't usually try to criticize the courts or the legislature, but I will tell you at the end of the day, they adopted the minority view. which, again, 48 other states do not follow that. But they took the view that if someone bought something like gas in one of the examples I gave you for Chevron and somebody else got the thing for free, that they thought that was illegal, and they adopted the minority view. But this clears that up, and we're no longer in that circumstance. And again, as you and I spoke about, the person who enters for free as opposed to the person who purchases a product and is entered, they have to have the same opportunity to win the contest. And it allows now non-profit organizations to do it as well as for-profit organizations. That is the essence of what we've changed in this law.
Jacobs or Randall? Somebody's light's blinking over there. Okay. Any other questions from the committee of the author or his counsel? Any questions? All right. Let me recognize first Representative Collins.
After looking at this, I have a question for the chairman. The effective date on this is July 1, 2007. Should that be amended to 2008? Okay. Then I'd make an amendment on line 26, page 2. This act shall become effective on July 1, 2008. Strike 2007, make it 2008.
In both places?
In both places, yes. And line 28 as well. And I'm going off LC 283355.
Is there any objection to that amendment? Hearing none, that amendment is adopted.
And I was going to make a motion at that point to do pass.
Okay, let me go to Representative Abrams. Well, you know, I've got him on my mind because he's dropped about 10 bills, and they all came to this committee. Every time I look down, it's his bill. So I'm sorry.
No problem. I actually have a question, and this refers to the difference between the substitute and the current bill. The only change from the bill as presented to the substitute was the language that changes Federal Internal Revenue Code as amended and strikes the language as amended, which I think is actually appropriate. And I would
that is correct, and our Chief General Counsel said that as amended was correct.
So we do want it as amended?
Yes.
Okay. That was my question.
Okay, thank you. Okay, further questions from the committee? Further questions? Representative Abdul Salam.
Mr. Chairman, just for clarification, which bill should we be working from?
We're working off LC 283355.
Thank you.
Further questions? If not, recognize Representative Collins.
Mr. Chairman, I'd like to make a motion to do pass LC 283355 as amended.
By committee sub?
Committee sub, yes.
Okay. Is that your motion by committee sub?
Yes, I apologize.
Okay.
Sorry, Jill.
All right. Vice Chairman Mumford has seconded that. Is there any discussion on the motion? Any discussion on the motion? Hearing none, all in favor of giving House Bill 259 a due pass recommendation by committee sub, please indicate by raising your right hands. Any opposed? It will go to the Rules Committee with a favorable recommendation, Representative Geisinger.
Thank you, Mr. Chairman.
All right, House Bill 333, Representative Starr, pleased to have you with us today.
No, not 336, 333.
333.
336.
Thank you very much, Mr. Chairman. Members of the committee, I bring before you House Bill 333. You know, since I've been here, I've heard so many people say about this is a simple bill that complicates a lot of things. But this happens to be a simple bill, I think, that stays simple if we can keep it simple. In counties like mine, Clayton and Henry, which I represent, we have a number of police law enforcement agencies. And under current law, the responsibility for disposing of weapons or that were used in the commission of a crime falls to the sheriff. And what this bill simply attempts to do is to provide that the agency involved in confiscating and investigating and having the prosecutorial responsibility also maintain the responsibility for disposing of the weapon. It's a fairly simple bill in that regard. It avoids I was talking to my sheriff in Henry County this morning, and I spoke with my sheriff, and I didn't speak to him this morning, but last year when we had the bill, this bill came through Representative Monsford's subcommittee with a due pass. And they are all in favor of that bill. I've had a chance to speak to the district attorney from Henry County who was here this morning, this afternoon, if there are questions that we can ask, who is also supportive of the bill. And I would hope that we get favorable consideration.
Representative Starr, you've got questions, and we have a couple of people signed up. First of all, Representative Bearden.
Thank you, Representative Starr. I know you said we could make it simple, and after we talked, I think that may have been in reference to what we may have talked about earlier today.
Yes, sir.
There's a couple of questions I was going to ask you about. On page 1, starting on we'll start with line 14. And go through let's say till the beginning of line 18. Right now in Georgia, if you're out hunting and then you happen to walk across WMA, which is a wildlife management area, due to this code section and the way it's written, you could actually have your firearm, although you didn't know you was in the WMA, seized and also sold. If you're in your vehicle, because of the way the code section is written, and you're a law-abiding citizen, and we'll use a case in Liberty County where two gentlemen had firearms. I think one was on his thigh, the other two was on his person. They spent the day hunting, coming back. I believe they had a jacket on, got pulled over. Let the officer know they had the firearms with them. To my knowledge, there was no criminal background on either one of these two subjects. I believe all 5 or all 6 firearms were taken and seized. And now these people's personal property is going to be either sold or destroyed. And they didn't do anything, but they were in their own vehicle. And that's one of the areas that I talked to you about, and I'll ask again, will you have any problems if we made a couple minor amendments between line 15 and 17 to make sure that if you use a firearm in commission of a crime against a person or a felony, by all means, take the weapon, dispose of it, sell it, whatever you need to do. But if you're a law-abiding citizen, just happen to walk through a WMA or maybe in your vehicle thinking that you're obeying the law and you get pulled over, that they can take your firearm, charge you, but at the end of the case or in the disposition that you get your firearm back. Would you have any problems with that? Or
well, Representative, a law-abiding citizen could carry a gun into the airport.
No, sir, they can't.
And so in this instance, when you say law-abiding, this says when final judgment is entered finding a defendant guilty of having violated the law. So just as that would be inconsistent with your statement to me, I'm suggesting that yours, using that example, is inconsistent with what is currently in this law.
What we're looking at is the person would be charged with carrying a concealed weapon, where it may be on its leg and maybe not 100% visible from the officer's view.
And that becomes, I'm sorry, go ahead.
And that would be carrying a concealed weapon, which would cause that firearm to be seized and sold.
And at that point, he is no longer a law-abiding citizen because he would have been found guilty of violating the law. And because he's found guilty of violating the law, his weapon is confiscated. And under current law, it would then be disposed of. And it is not my intention with this bill to change current law.
I understand what you're trying to do with the selling of the weapons. But again, just because someone wanders on a WMA or someone's in a vehicle, that is an extension of their home, they're just not granted the same amount of privacy that they are granted in their home, but they have the right to have a gun in their car anyway, as long as it's fully exposed. Now, as ex-law enforcement officer, the firearm may not be fully exposed depending on what side of the car I approach. And now then, we're going to take someone's property and sell it. If they want to make the charge under current law, they can. But I'm just saying it's their property. They should at least have a chance to get it back at the end of the arraignment.
The question of whether that should be illegal or not is one for another day. But the fact of the matter, it is illegal, and the only way that they will lose their weapon if they commit a crime involving that weapon. So I appreciate your desire to use this vehicle to change current law, but that's not what I want to do with respect to that particular aspect of it. All I want to do is to make it this consistent with what people are doing right now, and that's in many instances going and petitioning the court to have these weapons destroyed. And we would just like for Henry County, Clayton County, all other departments to be able to destroy those weapons or dispose of them themselves, not to decide whether or not the negligent or forgetful possession of a weapon in an area where it is against the law to possess it should be a matter of this bill.
And I do appreciate you bringing it forward. And sometimes when there's at least 77 different code sections in Georgia law that mention guns and firearm laws, it's hard to keep up with every one until one just happens to pop up and it brings your attention to it. So I'll stop the question until the proper time.
Representative Lunsford.
Thank you, Mr. Chairman. Representative Starr, if it would help clarify this any, Mr. Chairman, I just wanted to mention to the group that actually two of the counties that Representative Starr represents, one of those counties, you happen to have our senior Superior Court judge here who actually is in charge of sending those weapons out and convicting the people. We also have our district attorney who happens to be chairman of the Prosecutor's Council. So if they could shed light or possibly help Representative Bearden clarify that, I'm sure they'd both be willing to help if we could.
Nothing like being put on the spot, huh?
No, sir, it's not. Well, it's easy to do when you have the microphone. Arch is used to it, Mr. Chairman. But
many of us are wondering, Representative Lunsford, why your judge and your DA are around you at all times.
Mr. Chairman, I understand the condition of my probation. Someone has to monitor my ankle bracelet. But with that being said, and if I could elaborate, I am one of the co-sponsors on the bill with Representative Starr, and I wasn't trying to throw him into the briar patch on this. And Representative Beard and I have talked over the weekend. I understand Tim's concerns. I really do. And I think they're valid concerns. In this situation, all we were trying to accomplish was we've had a police department as well as a sheriff's department for a number of years, and as well as 11 other jurisdictions in the state of Georgia. There's 12, I believe, total. And under current Georgia law, since the police chief and the police department has possession of the weapons through the chain of custody, when Judge McGarity or one of the other judges has finally convicted them, we can't do anything with the weapons. They're just staying in a storage room. We can't dispose of them. We can't trade them in for other firearms. We can't do anything. They just pile up in a storage room. And what I understand, we have many years' worth of weapons just piled up in there, and there's nothing they can do with them. And so I apologize to Representative Starr for throwing him into the briar patch on this one. We were just trying to clean up code section with a little housekeeping. But if we could work with Representative Bearden in the future, I'd love to. If we can draft an amendment that would help, where it was actually used in the commission of a crime instead of suspected commission, I think may make Representative Bearden feel a lot more comfortable. I don't know, but we've got DAs and judges here that can probably help us with that verbiage real quick if the committee so seems fit to do that.
They're not jumping up. And
No, so they aren't breaking their neck to get to the microphone.
Chairman Franklin.
Thank you, Mr. Chairman. Representative Starr, I don't recall whether you were here or not when we discussed the bill immediately preceding yours.
Yes, sir.
And while the General Assembly had clear intent in the law that was adopted, saw, and we heard Representative Geisinger tell us how the courts ignored that intent and went off in a different direction in a ruling. And I'm of the opinion that, and I hope you are, that out of an abundance of caution, if there's a way that we can protect the people of the state of Georgia, that we might want to consider the type of language that Representative Beard is talking about out of an abundance of caution.
You are making a logical connection here that I'm not able to follow. I don't see the connection between what Representative Bearden is doing and suggesting what I'm trying to do. I think he has a legitimate issue. We talked about it. I understand what he wants to do, and he wants to use this vehicle to do it. I'm just not interested in supporting that effort.
Is it you? Okay. Chairman Knox.
Mr. Chairman, I wonder if the chair would consider a motion. I'd like to make the motion if the chair would consider it, to defer discussion of this bill to perhaps the next committee date. In spite of the good work that's been done by the subcommittee, seems like there's some concern about some of the issues in the bill that might be able to be resolved before we had to take it up again in order to preserve Representative Starr's bill and not unnecessarily load it up with baggage and try to write a new bill here today. It might be during the committee hearing. It might be well to defer consideration until the next committee day.
Second. Representative Starr, you understand what the motion is actually it's a motion, I think, to postpone to a date certain.
That'd be correct.
To postpone to Wednesday, 2 days from now. We will meet at 2 p.m. And I would ask you, because we want to be helpful to you, and I hope you understand that, but I would ask that you and Representative Bearden and perhaps Representative Lunsford sit down, and anyone else that chooses to want to be in that conversation, and see if you can work out this issue prior to that time. Is that okay with you?
If that's the will of the committee.
I think, is there any objection to the motion? I think that's the will of the committee today. So we'll put this back on the agenda for January the 30th? January 30th.
Okay.
Wednesday. Thank you very much.
Mr. Chairman.
I'm going to turn the committee over to Vice Chairman Mumford up for the final bill. 578.
Take up House Bill 578. You should have a substitute in your package, LC judynon012808. Mr. Ralston, you carrying this bill?
Thank you, Mr. Chairman, members of the committee. This is a bill that came through this committee last year. It was brought at the request of the district attorneys and had a lot of input from the Attorney General's office also. Mary Beth, you want to be a part of this discussion up here too? Because I'm going to recognize and ask you all to sort of take the lead on this. And basically, Mr. Chairman, what this does is build in some timelines on the habeas corpus portion of the appeals process in capital cases. Mr. Chairman, if it meets with your approval, I would ask that both Mr. Floyd and Ms. Westmoreland be recognized for an overview of the problem and how this bill seeks to fix that.
All right. You want me to take up the brains first or the beauty first?
It's the same thing.
I'll hear from Miss Westmoreland first. I think she's both. Go right ahead.
I know she's both.
Mr. Floyd and with the DAs on trying to look at a particular part of the death penalty process is in the habeas corpus area. For a short history, since this bill did come through the committee last year, I'll make it short. There was some legislation several years ago to try to put timelines in the code section to address the death penalty habeas corpus hearings. And what ended up happening was there was a provision in the code to allow for timelines to be put through the Superior Court rules. That did happen. Rule 44 of the Superior Court rules has those timelines in it now. In reality, those timelines have not exactly had the effect that I think was desired. There was some concern about what can we do to try to tighten up the timelines, make them more readily enforceable. The suggestion was, what if we codify some of those timelines? And that's basically what this bill does, is take some of the timelines from Rule 44 with some modifications to them, to put them in the code, and also to simply provide a reporting function for the judges. So, and there are a couple of provisions. One is dealing with filing of briefs after the close of an evidentiary hearing in these cases. We all recognize these are lengthy cases. It takes some time. The rules provide for the filing of briefs within a certain time after the hearing is completed. I believe 60 days currently for the petitioner, if I'm correct. And 60 days the petitioner files briefs. What this statute would do would provide for the time period for filing briefs to run from the filing of the transcript of that hearing, which gives everybody some extra time and also allows them the benefit of having the transcript. So, and it also adds another 30 days. So the petitioner now has 90 days from the filing of the transcript. That part is codified and actually trying to give something concrete, but also a realization of the reality of what happens. The other part is on the second page of the bill, beginning on line 7, dealing with the findings of fact by the judge of the Superior Court in these cases. Findings of fact and conclusions of law are required. The judge has to do it, or it simply will get sent back by the Georgia Supreme Court. In a realization that these judges have other commitments, and these are cases outside their circuit, there was some, I believe, originally the rules provide for the judge entering a ruling within 90 days of the filing of the last brief. That, I believe, was how the bill was drafted originally. It was extended to 120 days last year. It also already has built in the fact that we've already allowed for the time for filing the transcript, so there's some extra time up front. And if the judge, for some reason, can't get the final order done in that time frame, then it sets up a reporting mechanism. So the judge sends out a letter saying, here's why it's not getting done. And it may be the judge has 2 other trials and a death penalty trial in his or her own circuit. And that's, from my perspective at least, we get phone calls from victims' families a lot going, why hasn't this happened, why hasn't that happened? If I can point to a piece of paper where I see the judge has these other commitments, it's happening, but if there are other things that are going on, then that gives us something to point back to as well. And it's really an effort to try to look at a part of the process where things can get bogged down and try to expedite that process.
Mr. District Attorney?
From the District Attorney's perspective, we are not parties to the civil action, the writ of habeas corpus. We're more often witnesses, but we have an interest because these are our cases that we have dealt with. The trial of the case dealt with the victims, as Ms. Westmoreland has indicated, and the reason that I became interested in this is not because of not how most judges deal with this. Most judges deal with the habeas corpuses in a timely manner, but there are some aberrant cases that have gone as long as, I believe, 6 years, where everything has been done, but the judge has just not ruled for whatever reason. And there are some general persuasions in this bill that we hope will encourage judges that, as I understand it, volunteer to do these death habeas. So we did not seek to put something in here that was too onerous. But I will say that the District Attorneys Association has taken up this issue and has voted it as one of its top priorities. So as a group in the state of Georgia, we are interested in in the timely ruling of the writs of habeas corpus.
All right. Any questions for either of these two witnesses from anyone? Mr. Tom Knox.
I think this is for counsel, actually, Mr. Chairman. With respect to the bill itself, looks like the predicate of that code section refers to uses the term first, not first impression, but what is it? First appearance. I'm sorry, but it says first appearance state court. First time state court proceeding. Just out of an abundance of caution, since this is capital cases that this is involved in. And then on the second page we talk about the superior courts and the superior court counsel and so on. I don't know how much difference, if any, it would make, but if it needs to be corrected, this would probably be a good time to do it, because state courts in this, I guess even though they're inferior courts under the jurisdiction of the superior court, we probably ought to be consistent in the terms and language, I'd guess, unless there's some reason to say state court in the predicate there. Are you following me at all? Am I making any sense?
I think probably the reason it says that is as opposed to federal habeas, but that might need some clarification.
If I may, Mr. Chairman, I think when it was drafted, and that's language that I believe may have been in there when 91447.1 was put in initially. It was a different filed in state court as opposed to federal court. Habeas corpus cases have to be filed in superior court. Jurisdiction is in superior court solely. So how that's worded, I don't have a problem with it if we need to change the preamble.
I don't know that we do either. It just raised a question. It just occurred to me that it's not. I like being consistent, even if I'm consistently wrong.
And again, the effort when the statute was originally put into place was to differentiate between state and federal, and also a first-time state habeas and one that's filed in state court for the second time, which is generally when we have an execution date set, and there's just a whole different set of rules come into play. And it was to indicate these are not meant to apply to those cases. They're meant to apply to cases that fit in the box of the first time a petitioner is filing a state habeas corpus proceeding, which to me means something very specific, but I can understand that when we're dealing with state courts and superior courts and like that.
Further questions, Mr. Chairman?
Go right ahead, Representative.
Are y'all involved in a federal habeas action? You do that too? Okay, well that makes more sense, I guess. I don't know if I realized that. Okay, well, what say you, Legislative Council? Is there anything we need to concern ourselves about? Okay.
If Ms. Westmoreland thinks it's all right, it's probably all right, because she's going to be the one that has to defend it anyway. Another question down here. Is it you?
Yeah, thank you, Mr. Chairman. If I could ask
Representative Franklin.
If I could ask Chairman Ross, I'm looking at subsection D on page 2, and I like the idea of trying to speed up the process. And in the first sentence there, starting on line 7, where the judge of the superior court shall make written findings within the 120 days. But then you go down on which is great, trying to speed up the process. But then on the next sentence, starting on line 10, well, if they don't do what we just mandated that they do, then we give them another chore to do every 30 days for violating the first sentence of that subsection. And I'm just wondering, if we really want to speed up the process, should we just end subsection D after the third word of line 10?
If I may, Mr. Chairman, and Chairman Franklin, I think Ms. Westmoreland touched on this point earlier, and there may be very legitimate reasons for the delay. She mentioned having perhaps a very complex trial going on, or something. I mean, just because there is a delay doesn't mean that it's wrong, or that there is some wrong being done. What this does is basically if the court cannot meet this mandate, then they can explain why they're not meeting it. But I think that I know that there were a few Superior Court judges that may have had an issue about this, and I think that this does at least allow a little cover in those cases, and that's what we were trying to do.
If I might respond to that too, I think you have to recognize that some of these cases are much more complex than other ones, and of course all of these cases involving the death penalty are usually pretty complicated. But there could be the records in these cases and the evidence which needs to be reviewed can be voluminous and could take quite some time to go for anybody to go through, especially one person reviewing it.
Yeah, I was just concerned that if we're mandating a report to be issued in 4 months, and then in the very next breath we're saying, but if you don't get around to it, that's okay. Just do this other thing here. Then that raises the question. Well, what if every 30 days they don't give their timely response? And at some point, if this body enacts legislation that says this shall happen, at what point do we really mean it?
Any other questions or comments from anyone on the committee? If not, we'll hear from Judge Stevens now.
Chairman, with your permission, I would like to introduce Judge Arch McGarity, who's the Chief Judge of the Flint Circuit, which is Henry County, and is also the President of the Council of Superior Court Judges right now. I feel strange because usually it's lawyers asking me for more time, so I'm in the position of asking for more time. We have 34 pending death penalty habeas corpuses now in the Superior Court, and as was mentioned, they're handled by volunteers. Each judicial administrative district is supposed to come up with 3 volunteers who will do habeas cases. And we have that spread out among active judges who already have full caseloads and are already busy doing a lot of other things.
Could the chair interrupt you there just a minute?
Yes, sir.
How do you define a volunteer in situations like this?
Well, we ask for the judicial administrative district judge to find us 3 people who will say they'll do it. And then if they won't do it, we volunteer them on our own.
That's what I thought.
So what we're interested in doing is
like
keeping those people. Right, exactly. We're interested in keeping those people who have indicated a willingness to take these cases on, because we have to spread them around the state, because you couldn't possibly ask one judge to do all the habeas cases. And so what I'm asking is to make a very small change on page 2, line 8, and change the 2 to an 8. So we would have 180 days. And I think that might solve some of the problems that Representative Franklin is right out, because I think you'd have fewer instances in which you've got judges who are filing reports saying this is why I'm 30 days behind, or this is why I'm 60 days behind, if you gave us 6 months from the filing of the last brief to take care of that business. I think that would make our volunteer judges a little bit happier. So I would request that you make that change.
Does the author of the bill have a position on that request?
Y'all have.
Mr. Chairman, I would yield to your wisdom brought to the bill. I just remind you and the committee that we extended it from the rules to call for 90 days to 120 days, and that the aspect of the time starting to run from the filing of the transcript is a significant period of time. I think the rules call now for 30 days. I think in reality it's longer than that. So there's a long period of time, but I'm certainly not troubled with the judges over 60 days.
And one thing is Representative Montford pointed out, you got thousands of pages of transcripts from the trials. You've got hundreds of pages of transcripts from your evidentiary hearing. You've got tons of exhibits. And so these are the kind of cases that take a significant amount of time. And you want, you want to have some outside parameters, but I think it's important to reemphasize the fact that it's sort of it's the norm for judges to have these done a lot sooner than this 180 days, and it's only we're only dealing with some who may take longer than they should, and so I think with 180 days, that I think we would be happy with that amount of time.
Is that the only concern that y'all really have then?
I think so. Given 180, I think that if you can't get it done within 180 days, then you ought to have to explain why you haven't done it.
Okay.
And I think any judge would be willing to do that.
In light
should
of that,
be willing to do that anyway.
In light of that comment, Mr. Chairman, I would accept that as a friendly amendment.
All right. We don't have to vote on a friendly amendment, I don't think. All right. Is that all the any questions for Judge Stevens beyond his Mr. Franklin?
Thank you, Mr. Chairman. Yes. So if I understand right, we're going to require a judge, instead of the rule of 3 months, we proposed, or Chairman Rawson proposed 4 months. You would like to extend the time to 6 months.
Yes, sir.
But they still have the we don't mean it. You want to keep the we don't mean it. It's not really 6 months clause in there. Whether the want to keep that in there.
Well, we hadn't requested it, but we weren't going to object to it if the chairman wishes to keep it in there.
So it's not go from 4 months to 6 months and then delete the rest of the paragraph. Is that what you would like to see? Or?
I'm not requesting that. No, sir. But there are two things that can happen to you if you don't do what you're supposed to do. If you codify this time limit, the JQC, you can be brought up for the JQC for not doing your job, and you could also what was the other one?
Mandamus.
Oh, you could be a mandamus, which nobody really ever wants to do. But that is an option.
Thank you, Judge. I think that's all we have.
Thank you very much.
Yes. Tom, is it done? And looks like you're with ATM, which is someplace I get money. That couldn't be right.
That's my poor handwriting. That's attorney.
Attorney. Oh, okay.
It's a place where they take money.
You should have been a doctor.
Mr. Chairman, my children tell me that all the time.
All right.
Should have been a doctor.
Sorry about that, Mr. Dunn. I just couldn't read your handwriting.
I'm the executive director of the Georgia Resource Center. The Resource Center is a not-for-profit law firm that was set up by the State Bar 20 years ago to ensure that people who are sentenced to death here in Georgia are effectively represented in state and federal habeas proceedings. I'm here to object to the time frame that requires not what I do or the lawyers working with me do, but what the judges have to do. I have handled these cases in Georgia for the past 20 years, and I know how difficult they can be for judges. In the past 20 years, I'll bet if you were to count how many judges have ruled on one of these cases in 120 days, you could count the hundreds of cases on one hand. It's not happening. I'm not even sure that you've got more than 2, maybe. These cases are really difficult. The judges volunteer to do them. They do them in addition to their regular work, and I believe 120 days is not realistic. And I think this committee should be concerned about it for one primary reason. In 1995, Congress reformed the federal habeas to ensure that state courts really were the main arbiters of what trials are fair and constitutional that go on in their state. I think if you put an artificial timeline requiring state courts to make decisions within this artificial timeline, a timeline that we know from practical experience is not meetable, I think that causes problems with federal review and is not what this committee is trying to do with the bill. That's my concern, that we're really adding additional issues that could be brought up in federal court. I'm concerned that it's not a problem that needs to be fixed. I think, as District Attorney pointed out, there's a handful of cases maybe that sit for a while.
I think if you were to pass the 120-day requirement, the aberration would be anyone being able to meet it. So I think any rule that we pass that can't be meted, practically speaking, is not going to help us solve the problem. I really think that a timeline that is set in stone is the wrong thing to do, and I really think 120 days is just not possible.
Thank you very much. Are there any questions for Attorney Dunn? Don't see any. Thank you very much, Mr. Dunn. Sandy Michaels, you had signed up to speak.
Sandra Michaels with the Georgia Association of Criminal Defense Lawyers. Our association met this weekend for a winter seminar. This is one of the bills that was brought to our members' attention. And it's one of the very few rare bills where our association is split on the issue of. What our members were very concerned about, the non-death penalty attorneys were very concerned that there was not a timeline for the judges in non-death penalty cases. Our practicing death penalty attorneys are extremely concerned for the very same reasons Mr. Dunn raised, that on page 2, paragraph D, that there were these timelines put in for judges to issue their order. The main comment used, and I think Mr. Dunn used it, was it's just not a practical deadline. For those that do this work, if you get a death penalty case I was appointed to on habeas, state habeas, took me a week to read the trial transcript, and the main issue in the case is ineffective assistance of counsel because they presented no mitigation. So if you could just imagine if they'd actually presented a mitigation case with it, how much longer it would take. What we all wanted the judges to do is to read the materials as carefully as we do and make their ruling. And putting 120, or even with the utmost respect to Judge Stevens, 180, is not going to be a practical purpose. And the concern, I think, that you raised, Representative, about having them file a report is going to put undue pressure on the judges to just hurry a process along that shouldn't be hurried. The defense lawyers sat down with Ms. Westmoreland last year, and we have no objection to petitioners having to file within a certain amount. We had no problem with that. I think it was at 16, and we agreed that 90 would be more reasonable. But to put a limit on the judges to make this file for, as I think Mr. Floyd said and Mr. Dunn pointed out, a handful of cases is setting up constrictions that are just bound to end up in more litigation down the road. And we would ask that you not put in subsection D of the bill.
All right. Any questions from anyone? All right. Thank you. All right, that's all the people that had signed up to speak. Is there anyone else who wants to speak on this before we take a vote? I don't see anyone. Is there a motion before the committee on this bill, LC 292814S? Mr. Franklin.
Move do pass.
Move do pass. Is there a second? Second by Mr. Setzler. Any discussion? Seeing no further discussion, all those in favor of the do pass on this bill, please raise your right hand. All those opposed, seems to be one opposed. It does pass.
As amended.
As amended, yes.
Okay. Let me see the sign-up sheet. Kelly Connett, John Monroe. We had a couple of people that had signed up on 333, and I just wanted to let them know that we would certainly hear from them when that bill comes back on Wednesday. Okay, that's all the business to come before the committee today. Yes, you have some announcements in your packet, including a group that wants to visit with us at lunch tomorrow. So please take that with you. No, nothing else to come before the committee. We will stand adjourned. We'll meet again on Wednesday afternoon at 2 p.m.